Joe Gorfida, your city attorney, and for the next 4 hours, the first comment that was made was, "Joe, good to see you." The second comment was, "How long is this going to last?" So, when I've done this in the past, we try to get it done in an hour. I don't think that will be difficult. Let me start by asking a question. How many of you in here, this is the first time you've ever been to training for the board or commission that you serve for? First time you ever have seen me prance up and down the front here preaching? Okay. How many? Keep those hands up. Keep those hands up. Okay. On Saturday, I had the opportunity to sit through a retreat for another municipality. And the facilitator started out, it was actually something interesting that I never thought of. And if you think about it, when you serve on a board or commission, you're appointed or elected. Most of you here are all appointed with the exception of the city council being elected. You get appointed or elected and you go and you sit on that board or that commission, and most likely you may say something or do something and you draw a strange look from the city attorney if the city attorney's there, or from another one of your commission members or board members or the city manager, and afterwards, well, you shouldn't have done that, or you can't do that. And if you think about it, we never go to school to learn to be a board member or a commission member or a P&Z member or a council member. There's no school. A lot of times we get thrown into these meetings and we have no experience. There's no practice, right? Because the meeting's live. A lot of times it's on TV, on cable, so there's no practice. And we don't get to have practice meetings. So tonight is kind of our first opportunity to have school, if you will. And again, it's only an hour. And then there's usually one other opportunity during the year where you have training that's either done by myself or somebody else as it relates specifically to your board. So tonight's training is going to be a broader category, and it's essentially going to be ethics. And we're going to talk a lot about the state laws and the city charter. So as you're sitting there, there's going to be some things that will not be applicable to your board. Common sense will tell you it's not applicable to your board. There may be some things that you're not really sure if it is applicable or not. So we have civil service members in here, those that are on the civil service board. There's going to be many things in here that aren't applicable to the civil service board, but are applicable strictly to the city council or an advisory board. And I'll try to point those out as I go through the presentation. If I forget to point it out and you have questions afterwards, just stop and ask. If you want a copy of this PowerPoint, Keisha, you can make this PowerPoint available to them. Also, this presentation will be played again. I should say play again. It will be available online if you want to go back and criticize me for something that I said when I deny saying it. Okay, you'll be able to go and find it unless I get to it and edit it out before you see it. So I wouldn't do that. It will be available. This is not live tonight, so any mistakes I make, I can change them. So if we're thinking about where do we go to, or the books that we go to, again, this is the speech I say every year. The books are the places that we go when we want to figure out what we can and can't do. Where do we go? And we go to the city charter. We are a home rule city, and we have a city charter. And the city charter lays out sort of an outline for a lot of the boards and commissions and some of the duties of the boards and commissions. And it doesn't say a lot, but it says a little bit. It's a starting place. The next place we go to are the city ordinance, and the city ordinances have specific provisions as it relates to boards and commissions. Those of you who are in the domestic violence committee, we're looking at making you an ordinance and putting you in the book, per se. So you can go and you can find your code of ordinances online, and it does address your specific commission or your committee. And where's the other place that we go? We go to state law. And a lot of the stuff we're going to talk about tonight is related to the state law. And the state law lays the basics out. It gives us the basics of what we can and what we cannot do. However, as a home rule city, what we have done through our code of ethics is we have set the bar a little bit higher. So there's going to be things that I talk to you tonight that are a little bit stricter than state law. And you'll see some of the changes that have been made in state law. You'll stop and think it was probably good that we have these types of stricter standards here in DeSoto. So let's start with the code of ethics, okay? The conduct of DeSoto's public officials is governed by the city charter, city code of ordinances, the code of conduct, and those are all in the actual code book. If you go online to Franklin Legal Publishing, you can find all these. And then Chapter 171 of the Texas Local Government Code, which is the state law provisions that we'll talk about, okay? Interesting enough, everyone asks this question, who does the city code of conduct apply to? Well, it only applies to those commission and board members that are elected and or appointed. It does not apply to city employees. The personnel policy manual applies to city employees. The code of conduct does not. Interesting couple changes this year, and I want to just point out the changes in law real quick, just so you're aware of them. It doesn't really have that big of impact on what you do at this point, but there is a new change. It's called Form 1295, named after the House Bill 1295. And what that does, and it's more of this transparency in government. We're seeing more and more of that. And what that does, it actually now requires those that are going to enter a contract with the city, if that contract is approved by the city council, regardless if it's for $1 or $1 million, if it's going to be approved by the city council, or it's a contract for $1 million, which would be approved by the city council, the vendor has to go online and electronically file this call. It's called a certificate of interested parties. And what it's required to do is they're required to list those individuals that were involved in the process. The city, and then they submit the form, and there's questions that they answer, whether or not they have any type of relationship with anyone at the city or any official at the city. They submit the form, and then once the form is submitted, the city goes online with the number that's spit back to the contractor, and we have to acknowledge it. We also, on our side, have to fill out a form and list anyone that may have a conflict. And what that does is that basically is transparency. Anybody in the public, you can go out to the Texas Ethics Commission and you can look up all these contracts now that are approved and see if there's any relationship. It may not be a violation of state law, but is there any type of relationship between the vendors and anyone at the city or anyone at the city who has some type of involvement in approving that contract? And interesting enough, it is a violation to approve a contract until that form has been acknowledged by the city. So again, more transparency in government. Nothing that you have to worry about as it relates to what you do on a board or commission, but it's interesting out there if you have, especially the city council, if you have authority to approve contracts, you'll know that that form is getting filed before that contract is approved. And again, Form 12, it's called Form 1295. You can actually, if you're interested, you can go out on the Ethics Committee website, just type in Texas Ethics Commission, Google, always our friend. Type it in, and they actually have a quick little 15-minute 1970s webinar, is what it looks like, that explains the process, okay? And then House Bill 23 does apply more, but it's a local government officer's conflict disclosure statement. Again, you can go online and you can find this form, but if the vendor has a relationship with any officer, so that would be a city council member. Again, we don't really have anyone else other than the city council that is approving contracts. But has any relationship with an officer or family member and is receiving taxable income exceeding $2,500 in a 12-month period preceding the date the officer becomes aware that a contract has been executed or before the city is considering entering into a contract with the vendor. So again, it's another form that needs to be filled out, and the threshold is a lot lower. It's $2,500 in a 12-month period. And it also now includes gifts with aggregate value of more than $100. This applies to everybody from the standpoint if you are involved in or making a recommendation to the city council, or you're on a board or commission that has some type of authority such as the planning and zoning, and you have a developer for you, and you receive gifts from that developer. We'll talk about that, receiving gifts from a developer. Don't receive gifts from a developer with an aggregate value of more than $100. This form is going to have to be filled out. All right. So getting into the code of conduct. Okay, what is the code of conduct? It ensures the public officials are independent, impartial, and responsible to the citizens. Prevents any interest, financial or otherwise, direct or indirect, or engagement in any business transaction or professional activity of a public official to conflict with the proper discharge of their duties in the public interest. I know this is not exciting stuff, and I know I'm not competing with Monday Night Football tonight, so I'll try to wow you as much as possible, but it just doesn't have a real wow factor to it, and there's no other way to get it into your head sometimes other than reading what is actually in the code of conduct. But we'll get into some juicy, exciting examples here in a little bit. And again, the code of conduct prevents public office from being used for personal gain and ensures that the boards and commissions are at all times maintained as non-partisan boards. All right, what is a substantial interest? So now we get down to the nuts and bolts of the substantial interest, and it's a two-step, a Texas two-step, a two-part test, okay? So if you're sitting up here and you're like, do I have a substantial interest? Do I need to fill out a conflicts form? Do I need to step down and not get involved? You run this test through your head. And really the easiest, simplest way to think about this is look at your agendas in advance, okay? And whether you're the city council, whether you're the planning and zoning, whether you're an advisory board for that matter, if there's something on there and you look at that and you're like, I know that person. I work for this company. I solicited this person to come and do a presentation before us, and I'm going to get a personal gain from if the contract's awarded. Look at your agendas in advance so that if there's a question, you can go to your board liaison or to the city attorney, whoever you need, or to me, and we can make a determination, is there a conflict of interest? Because what you don't want to do is get into a situation where you think there's a conflict of interest, or you perceive there to be a conflict of interest, and there's not, and then you get criticized for not being involved or not taking part of the vote. A lot of times, as board and commission members, or council members, I get the questions, I'm like, well, I'm just not comfortable making that decision. I'm going to recuse myself, when there actually is no reason to do so. And as boards and commission members, we're put here by the people, or by the council members, or, and we're put here to make those decisions. So unless you really have some type of conflict, you shouldn't be stepping back and saying, you know what, I'm not going to vote on that, or I don't want to get involved. Understandably, there are sometimes things that are perceived to be a conflict, and that's when we need to have that conversation. Is there really truly a conflict, and do I need to step down and recuse myself? So let's start out with the simple two steps in a business entity. And what does a business entity mean? Okay, if I own 10% or more of voting stock or share of a business entity, or own 10% or more, or $15,000 or more of the fair market value of a business entity. Okay, so I'm an owner of a business and I own 10%, or own 10% or more, or $15,000 or more of the fair market value of the business entity. Okay, if I work for AT&T, most likely I'm not going to pass that first test. If I did, I wouldn't be, I wouldn't be standing here, but I wouldn't pass that first test. Okay. Next, you go down to the income interest. Funds received by the person from the business entity exceed 10% of the person's gross income for the previous year. So do I have an ownership or stock interest? Step number one. No, I don't have an ownership or stock interest. Step two, am I just an employee? Do I have an income interest? Okay, I work for AT&T. All the money that I receive is more than 10% of my gross income. So do I have an ownership interest, or do I have an income interest? And then you go to the next step, okay? And it's called the special economic effect analysis. Action, we can't just call these simple things, can we? So action on the matter involving the business entity will have a specific income effect on the business entity that is distinguishable from the effect on the public. Okay, so it's something that we're going to vote on. Is that going to have an effect, specific economic effect on the business entity that is different from the effect on the public? Okay, so a lot of times if you work for a big corporation and somehow that corporation is coming before the council for some type of improvement, it's not going to hit the special economic effect analysis. So those are essentially the two steps. Number one, do I have ownership or stock interest? If you say no, then you go to the next one. Do I have income interest? Okay, if you say no, you're done. You're done with the analysis. If you say yes to either of those, then you go to the next step and you said, will the action on the matter involving the business entity have a specific economic effect on the business entity that is distinguishable from the effect on the public? Okay? So those are the first types of substantial interest, whether I work for them, ownership, stock. Next is real property. Do I have a real property interest? And P&Z folks, listen up. Council, this is where a lot of times the question comes. And real property means person has an interest that is equitable or legal ownership with a fair market value of $2,500 or more, and it is reasonably foreseeable that an action on a matter involving the real property will have a specific economic effect on the value of the real property, distinguishable from its effect on the public. An official is considered to have a substantial interest under the Code of Conduct if a relative has a substantial interest under the Code of Conduct. And a lot of times this comes up in P&Z, where P&Z says, well, there's something that's going on within we're looking to rezone a particular portion of the city. My land is within that particular portion. Is that going to have a specific economic effect on me? Is this rezoning going to have an effect? And when we're talking about zoning or rezoning, the answer to that could be yes, it possibly could. However, if we're looking at changing setback requirements throughout the whole city, and those setback requirements are going to affect everybody as a whole, then you're not going to meet the substantial interest. So that is what's important, especially from a zoning, is look at those zoning items that are on there and see, is this going to have any implication on me specifically as a homeowner, or as a property owner, than it would from the general public as a whole. And we'll have some examples on that as they come up. And by no means do I expect you to absorb all this, because looking at your faces, you probably feel the same way I do, but I've done this about 100 times now. So just ask the question. Look at it. If you leave here with the only thing I want you to leave here with is read your agendas and ask the question if you think it needs to be asked, of whether or not there's any type of conflict of interest. Code of conduct. No officer of the city shall participate in a vote or decision on any matter in which the officer has a substantial interest. Okay, that's number one. What is a substantial interest? You work for the company, you receive income from the company, or you have property, okay? Work, income, property. Those are the three things just you need to remember. You represent or appear on behalf of private interests of others before the city council, any agency, board, commission, corporation, or committee of the city, nor represent interests of others in any action or proceeding involving the city council, nor voluntarily participate on behalf of others in any litigation to which the city is or may be a party. A lot of times no one tells us this, and a couple years ago, I was at a city, and I always like to tell stories about my other cities, and these are the things I edit and go back and take out of the tape, but they're using that as learning tools. But I had a city council member at one point in time that wasn't real happy about an agenda item, and his neighbor was up and speaking against the item, and so the council member jumps off the dais and comes down in front and says, well, I'm going to represent my neighbor. So common sense is you can't do that. You can't do that. But the same thing goes if you're on another board or commission and you're actually coming before the city council and representing or appearing on behalf of the private interests of others before the city council, board or commission. You just don't do that while you're a commission member, or committee member, or board member, or council member for that matter. Council members shouldn't appear at the P&Z to support an applicant. Okay. Accept certain gifts for any person that might reasonably tend to influence such officers in the charge of official duties. Okay. Don't take gifts. Do not accept gifts that are tended or reasonably tend to influence such officers in the discharge of official duties. And notice this caveat down here. It does not apply to an item with a value of less than $50, t-shirts, caps, mementos, or other similar promotion materials, or items less than $50. Again, if they're t-shirts and so forth that someone's handing out, the bank's handing out t-shirts, that's not an issue. Cowboy tickets. Let's talk about cowboy tickets, okay? I don't know how many times I get the call during cowboy season about cowboy tickets and whether or not whether or not that I can go to a cowboy game as a public official. X is offering me a cowboy ticket. Well, who is X? X, well, they're a developer. Or who is X? And they have something that's going to be coming up on the agenda. AT&T used to give them out all the time. They don't so much anymore. And it was all right about the time the franchises were going on. This was several years ago. And I always say, look at the face value of that ticket. Look at the face value of that ticket. And so you know what the answer is, what that face value will be. $0.00 $0.00 because they don't put a value on those tickets because they know that they're being used for that purpose. Not trying to thwart the law, but they don't put a value on it. And so my response is, do you really think that cowboy ticket is worth $0? Okay. Do you think that cowboy ticket is worth less than $50? No, it's not. What is a fair market value? So be cautious of taking cowboy tickets that are $0. And then don't ask them, well, can I give it to my son? Well, no, because your son is related to you by blood. And then I get the next call. Well, they're really just giving it to me as a friend. Well, how long have you been friends with them? Okay. So if you want to go that bad, buy the ticket, right? Code of conduct. No officer of the city shall have a direct or indirect financial interest in any contract with the city or be directly or indirectly financially interested in the sale to the city of any land, rights of interest in land, material, supplies, or services. And this is why we now have what I just showed you before on the new law that does require us to go online and file these forms. So there's basically a track record, if you will, of who's entering contracts with the city, and is there any kind of financial interest with anyone that was involved in awarding that contract to the city. So in other words, if we've got a panel in our purchasing department, sometimes we'll award contracts by a panel of 3 or 4 employees. Well, we then have to go on now and list those employees to make sure those employees don't have some relationship with the vendor who was awarded the contract. Again, financial interest requires that the officer receives an actual financial benefit from the transaction with the city. So in other words, if an employee's wife or child has some type of job with that company, and awarding that contract to the city would be a financial benefit, then that would actually be a conflict of interest. Okay, so what is an actual financial benefit from the transaction? Shall not include ownership in an entity's transaction business with the city where the ownership interest is less than 1%, or compensation as an employee, officer, or director of the entity transacting business with the city where such compensation is not affected by the entity's transaction with the city. That last bullet point is probably the most common, is especially for city council members when we are awarding something. They may work for a big corporation, and they will actually have no involvement whatsoever, will receive no benefit by that contract being entered into with the city, and so there actually would be no reason for them to have to recuse themselves. All right, again, thou shalt not use such person's official position to secure special privileges or benefits from such person or others, grant any special consideration, treatment, or advantage to any citizen, individual, business organization, or group beyond that which is normally available to every other citizen, individual, organization, business organization, or group, and most importantly, disclose confidential information. Most of the things that I've read off, the first 2 bullet points, that's not covered under state law. That is in our code of conduct. It goes a little bit above and beyond what the state law states is a little more specific. Let's look at that third one, disclose confidential information. We'll talk in a little while about what is confidential information. For those of you that are on the city council and on the planning and zoning, you have the opportunities when we go into executive session to become privy to what is confidential information. Many times everyone says, oh, it's against the law to go out of executive session and spew confidential information or what was told there in executive session. It's not against the law. It just makes your executive session that you went into it, for the most part, unlawful, because there was no purpose to go into that executive session if you're then taking that information and then telling people the information that was disclosed in executive session. There's a lot of times information in executive session that is not confidential, that if it is disclosed, it's not a violation. That's why we always read that language when we go into executive session. And for those of you that on some of the boards and committees don't have the option of going into an executive session, there's really not a lot of confidential information either that you would be privy to. All our boards and commissions are posted public meetings. So if somebody is there from an organization and they're telling you information that's confidential and you're thinking, wait, that's confidential, they probably don't want to be releasing that information. Someone should kind of remind them, hey, this is a public meeting. The information that you're releasing is essentially confidential, especially if it's somebody's health information. We maybe think of some instances where people have come before committees or commissions trying to talk about something. They get emotional and they start talking about someone's private health information. They don't want to be doing that because it is public. Code of conduct, again, no officer of the city shall use city supplies, personnel, property, equipment, or facilities for any purpose other than to conduct official city business unless otherwise provided by law or ordinance. So don't come in here and asking Keisha to run off your flyers for re-election or your badges or so forth. Also, act as a surety on any official bond requiring for an officer or employee of the city or for a business that has a contract with the city. Not run into that yet. All right, we're almost to the end of the boring stuff. We'll get to the exciting stuff next. Yes, it does get exciting. Hold on to your hats and seats. All right, what are some additional standards? No member of the City Council, P&Z, Commission, or Board of Adjustments shall participate in, vote on any land use matter in which such officer has a substantial interest in any real property within 200 feet of the real property that is the subject of the land use matter. This is the 200-foot rule, okay? If you live within 200 feet of the agenda item, stop, pause, make a call, okay? And make a determination on whether or not you're going to have to recuse yourself. Most likely you will. Let's talk a little bit about P&Z, Board of Adjustments. Again, look at your materials, look at the map. Sometimes the language in the agenda item will not specifically show you the exact location. If you receive the 200-foot notice in the mail, okay, it's going to apply. It's not a defense to say I don't check my mail. It's not a defense to say, hey, the city didn't tell me. I try to stay up with a lot of the zoning cases, and especially with the city council and where they live, just to make sure that we don't run into a conflict. So we do have a checks and balances in place, but that is one area we really do rely on you, both the P&Z, the city council, and the board of adjustments, to look at that material, the specific portions of the material, to make sure you're not within the 200 feet of the property. Interesting enough, some cities actually go out to 500 feet, so you may hear people talk in the community, oh, you're only 200. 200 is the minimum by state law, but some other cities do go out to 500 feet, all right? No member of the city council who is on the governing body of a nonprofit organization shall vote on any funding request by that nonprofit organization other than for membership or subscription dues or fees, or as part of the city's annual budget, unless the nonprofit organization has a governing body appointed in whole or in part by the city council. And then, with the exception of those proceedings allowed under the Code of Conduct, city council members shall not personally appear on their own behalf before the council, any board, commission, corporation, or committee, but may designate and be represented by a person of their choice in any such personal matter. So if you have a personal matter you want to appear before the city council, have your neighbor do it on your behalf. Okay, don't you do it. Don't get off the dais and come down here and appear before your own board. And it happens, believe it or not. This is always a good one. Think about your employment after you get off the council or after you get off the P&Z. But no past officer of the city shall, 1 year, you got a 1 year cooling off period from the date of termination of your relationship with the city, appear before the city council, any board, commission, corporation, committee, doesn't matter whether it's advisory, non-advisory, or final decision making, to represent the interest of another on any matter. Okay, so once you're off your committee or your commission, you got a 1 year cooling off period before you come up here to represent the interest of another on a matter. That does not mean that you can't represent yourself. You can come up here the next day that you're off and say, I don't like the way that you're doing something. That's fine, but you cannot represent the interest of another on any matter. And a lot of cities have this in place simply because what do a lot of council members do once they retire? What do? They become lobbyists or consultants, and you'll see them up here with the developers hand in hand, trying to promote one of the cases. All right, Code of Conduct. If any officer has a substantial interest in any matter pending before the body of which the public official is a member, the person must, before a vote or decision on such matter, file an affidavit on a form provided by the city, disclosing the substantial interest, and abstain from future participation in such matter. That's why it's always good to look at the agenda before. Let us know if you're going to have to file the affidavit so we can have it prepared in advance for you. The affidavits are available online. It's worth taking a look at the affidavit even before you have the conflict of interest, just so you know how to fill it out and if you have questions. And the next thing is leave the room. That's not a requirement by state law, but it's a good idea to leave the room. If you do have an interest, go to the back, go outside of the lobby, go out to your car, as opposed to sit here and give dirty looks to your commission members or board members or council members that they should approve or not approve the item. Again, I have all these little anecdotes or little stories, but I can specifically remember one case in particular when I first got into this business, and I wasn't really, I was a little green, and the whole part, and leave the room part, I wasn't thinking about. And one of the council members filled out the form, and he sat right in the front row, and the council deliberated the action, and he was moving around, making faces, and and it was somewhat obvious because he was the only person in the audience. One more than they usually would have. And so, of course, afterwards, that was just very uncomfortable for me to make a decision that we knew was going against, essentially his interests. So that's why we say leave the room. And you may be criminally prosecuted if you fail to file the affidavit. Okay, so if you don't file the affidavit, you may personally be criminally prosecuted. When we say criminally prosecuted, that means there has to be an intent, right? So it's not necessarily a defense to say, well, I didn't know if you knew. So, and as you can imagine, you can probably think of some cities that come to the forefront of your imagination that this has actually occurred where they did vote, they did fill out the affidavit, and they were criminally prosecuted. All right, again, on disclosure of real property interests, upon election, appointment, or confirmation of appointment, and thereafter on or before January 1st of each calendar year, every officer shall file in writing with the city secretary in a disclosure form provided by the city the existence and location of any real property in the city in which the officer has an equitable or ownership interest, including an interest of 1% or more in any entity which has an equitable or ownership interest in any real property. That's just so we have it on file, so we know if you do have an interest in the event that conflict is going to come up. And again, just putting on there the identification of the real property. You know, if it's just your house, we know where you live, so that's not going to apply. If an officer has an interest in an entity that will not disclose to the officer whether or not the entity has a financial interest in real property in the city, the officer may satisfy the disclosure requirements by stating such facts in writing to the city secretary. So, nepotism. All right, this is the good stuff. No person related within the second degree of affinity or third degree of consanguinity. Okay, by blood or by marriage. To the mayor, any member of the city council or city manager shall be appointed to any paid office, position, clerkship, or other service of the city. The prohibition shall not apply if a person has been continuously employed in the position for at least 6 months immediately before the election of the related member of the mayor or council member, or has been continuously employed in the position for at least 30 days before the appointment of city manager, if related to the city manager. Okay, in short, what does this mean? We will not employ your wife, we will not employ your children within the city while you are serving on the board of commission or within 6 months after the fact. And the reason for that is what? I mean, it's common sense, because you don't want to put the city manager in a position where he feels that he has to hire a family member based on the fact that you serve on the board of commission. So, all right, time to wake up. May a local official discuss or vote on an item if the effect of the vote on the official's business or property interest is no different than its effect on the general public. Okay, so a little quiz here. Can you vote on an item if that effect of the vote or against is not going to have a different effect on your property or your business interest than it would on the general public? Think back to the example we talked about setbacks, right? So what's the answer to this going to be? The answer is going to be yes. If no distinguishable difference between the item's effect on the local official and its effect on the general public. The answer to that is yes. Okay, adoption of setback requirements. All right, form of government. This is a little basics 101 that we all need to know. We are a council manager form of government. The way that I always like to explain, it's similar to a board of directors. You have your city manager, you have the council. The council is responsible for what? Managing the day-to-day affairs of the city? No, the city council is responsible for setting policy. If you look at some of your smaller cities, such as maybe the city that are general law cities, whether it be the city of Hutchins, they are general law cities, where the actual city council is more involved in the day-to-day affairs of the management of the city. They have city administrators, and the council there tells their city administrator how much authority they want them to have or don't want them to have. In a form of government that we are, a council management home rule authority, again, we set the policy. We hire and fire, or the council hires and fires the city manager, the city attorney, and the judge, and tells the city manager, sets expectations or goals of the city manager of what they want or what they want to be set, and then steps back and allows the city manager to do the managing, and then gets involved in the adoptions of the policies. Let's go on to, okay. Legislative body, what do? You approve the budget. That's where you can have control of your city manager, what your city manager can spend or not spend. You know, whether you want them to buy all those new police cars or new ambulances, it's through the approval of the budget. You set the tax rate, policymakers that determine the scope and function of city government. City council members and board commission members have no administrative duties. Okay, again, no administrative duties. Your administrative duties are vested in the city manager, who directs the workforce and manages the programs of the city in accordance with city ordinances, rules, regulations adopted by council. The reason I put that up there is, again, we don't, as council members or P&Z members, we don't really go to school, so sometimes we don't always know what our role is. If you look back to some examples of City of Dallas, it was probably close to, I'm thinking it's maybe close to 10 years ago, they are a council management form of government. They actually were looking at or proposing an election to change that to where it would be a strong mayor form of government where the mayor would actually step in and do the role of what the city manager does. So there is a provision that does allow for that under state law, although your charter would have to be changed to allow for it. So your charter with the people elected sets out that it is a council management form of government. Okay, boards and commissions are solely advisory bodies to the city council. And the reason I say that is you'll see in state law that it talks about, when we talk about open meetings and we talk about the Public Information Act, a lot of times with open meetings it says that it doesn't apply to advisory boards. Well, here in DeSoto, as well as almost every other city in the state of Texas, we've gone a step forward. We say that the Open Meetings Act applies to all of our boards and commissions, committees, advisory nature, which means we all go by the same rules, so it makes it easier. City charter prohibits city councils from giving any orders publicly or privately to city employees other than the city manager. All requests must go through the city manager, and council cannot delegate to, there's two twos in there, to boards and commissions authority it does not have. Therefore, neither boards or commissions nor any of their members have authority to direct city staff to perform tasks. So if you feel you're getting outside of your parameters as a board or commission member, stop, ask the question, hey, is this something that we should be doing, or is this something that staff needs to be doing? Because they're solely advisory nature, boards and commission members are not authorized to speak in the official capacity for the city. Interview requests from media, letters from attorneys, requests and responses. And this occurs a lot, especially in your smaller cities, where you'll have city council members that after a meeting the media may catch them and they end up speaking, and then, again, there's no school that tells us we can't speak, but they end up speaking, and what they realize is they just spoke on behalf of their city council and what their whole city council thought. And a lot of times that's not a good practice, because you're not authorized to speak on behalf of the city council. The city council speaks as a collective body. Anytime there's a lawsuit involved and someone sues a city council member individually, our argument is no, they act as a collective body. That decision was made as a collective body. It's like an executive privilege, okay? They try to depose you to get into your head. What were you thinking when you made that decision? We always will object to that deposition and say that they are a collective body. Their decision was made as a collective body, okay? But when you start stepping out of that role and you start speaking on behalf of the city council, it's a lot harder to make that argument or make that distinction, especially when you're dealing with zoning cases and developers who aren't happy about a decision. A lot of times they'll name the city and they'll name all of the planning and zoning or the city council members in that lawsuit individually. We'll step in, we'll represent you, and get you out of the suit pretty quick, as long as you're staying within your boundaries and acting as a body collectively in the decisions that you make. Okay, open meetings. As I stated, all of our boards and commission meetings are subject to the Open Meetings Act. We post all of them. We post them all out on the bulletin board. What's interesting is the past couple legislative sessions, because of all the new technology that we have, we're now required to post all of our agendas online. If you don't post it online, you can't have a meeting unless there was actually some sort of technical malfunction or technical breakdown. Technical breakdown isn't the city secretary forgetting to do it or hitting the wrong button. She's like, yes it is, yes it is, yes it is. It's just that you can't have the meeting. But with all the new technologies in place, some of the cities have tried to get it to where you don't have to put it out on the old-fashioned bulletin board out front. And we still are required, they didn't pass this time, we're still required to put it out in the bulletin board out front. For those people that are just going to walk up to City Hall and look at the bulletin board. The only exception to that is now is if you have electronic kiosks, you can put the agenda on electronic kiosks. So can you imagine driving by City Hall and seeing a whole 3-page agenda scrolling down the electronic kiosk, trying to read it as you're driving? Probably not a good idea. So, all right, so we've got the governing body. It's our quasi-judicial boards, commissions, subcommittees of city council. Subcommittees of city council. If a subcommittee of the city council is meeting, like our finance committee is a subcommittee of the city council, we still post those, still required. Because those subcommittees may be making decisions that they take to the city council. And what is the city council doing? They're rubber stamping them, okay? So we post our subcommittee meetings. Acts requiring notices of meetings, agendas to be posted no later than 72 hours before meetings. And by local city policy, our boards and commissions are required to follow the act. Okay? If you call me and you say, Joe, I don't see our agenda posted on the internet, or Joe, I don't see our agenda posted outside on the bulletin board, but don't look, okay? I'm gonna look. It's my responsibility to look. And if it's not there, you can't have the meeting. If you, as an individual board or commission member, you go online and it's not there, okay? It's truly not there. Not that it's hidden somewhere under one of the folders. It's truly not there. You cannot participate in that meeting. You have committed a violation, an illegal act, okay? It's not, hear no evil. If you're going there and you know that it's not been posted, you're in violation of the law. Okay, what meetings are subject to the act? Any discussion or deliberation by a quorum, majority, or between a quorum and another person regarding public business or policy with the board controls or supervises, or during which formal action is taken. Okay, in short, what is a quorum of your board? If your board is 5, we know what a quorum is. Make a decision. It's going to do what? If it's 5, what's it going to be? 3. If it's 7, what's it going to be? 4. Okay, quorum. We do have some restrictions for making decisions, passing ordinances, that there's a minimum number of council members, which is 4, that have to be involved. For a quorum, we're talking about that number, whether it's 3, whether it's 4. Okay, that's a quorum. That's how many people you need to do business with with a lot of your committees committees and commissions. If you are talking to one another about a piece of business that's on there, and it's only 2 of you, okay, it's only 2 people talking about that item, and you know that item's coming up, could it be deemed to be a violation of the open meetings? How many of you think in here it could be deemed to be a violation of the open meetings? Okay, and the answer to that is yes. Now you got to be careful with like the library board and so forth. You may be having a conversation and saying, you know what, I really want to get on the agenda that list of prohibited books. I think there's some things on there we need to add or we need to take off. Okay, that's not a violation, because what you're talking to is, hey, let's go to the liaison or talk to the liaison to get this item on the agenda so that we can discuss it. But if you're essentially having deliberations, even in numbers less than a quorum, you can be in violation of the act. And we're going to talk about how you can be in violation of the act in numbers less than a quorum, especially in today's technology world with text messaging. It used to be the phone. It's not so much the phone now, but it's the text messaging. As I tell the council up here, we all have our phones. The one thing we don't do, and as I tell all the councils and all the cities I represent, is to be text messaging each other during the meeting about that item that we're discussing, okay? And that actually came up in another municipality, and it was in the news that the council members were up there texting one another, deliberating through text messages, and essentially not, the deliberation wasn't so much being spoken words, but it was what they were sharing with text messages. When that zoning case was denied, the developer made a request for all the text messages, because he knew back then they were text messaging. It was obvious. So he made a request for all the text messages. A lot of you have your own personal phones that you're text messaging from. A lot of you have your own personal phones that you call from. And those records now become public. And once those records become public, you got to turn them over, and we have the tedious task of going through, whether it's your private phone bill, and redacting out those numbers which weren't related to city business and leaving in those numbers that were related to city business. And it's a very common tactic now that's used, especially if you have someone that wants to file a lawsuit against the city or is concerned that there were some sort of secret deliberations going on. They ask for all those. They ask for all of the your text messages. They ask for any calls you may have made. You don't see this as much down on the committee, like the library board. There's not as much of a concern, but it's more on the city council and on the P&Z level, where those true decisions are being made or being denied, for that matter. So you got to really be careful about how you're communicating and what device you're using to communicate. And I tell the same thing to city staff, because city staff, may have a device that's issued to them. It's a city issued device, but what's the tendency a lot of times to do? To use their own device. Okay. Same thing if you're sending emails from your private email account, make sure there's a recipient on the other side of your email account that's the city. So we're housing those emails. We have those emails somewhere in the event that someone makes a request for those emails. Because if you're not, if we don't have those and we have to come and retrieve your computer from your house, that's just something that you don't want to happen. And it happens. It happens all the time. More so than we, and it's usually the council members' computers that are being taken from the house to see if there was any email communication that was being done from their private email address as opposed to a city-issued email account. So just be cautious when you're sending emails out on your handheld. That's how we communicate, is on our iPhones, and we send those emails out. Where are those emails going? Is it something that should be maintained by the city? Should we be copying a city staff liaison person on that email so they are maintaining it? All right, notice, let's talk a little bit about the notice. A lot of times the question comes up, well, is the notice sufficient enough? And if I'm at one of your meetings, a lot of times I can become annoying because I'm like, oh, back on the agenda, not on the agenda. Or I'll say, this is related how, or bring it home, bring it home, make it related to the item on the agenda. And I do give a lot of leeway because we do sometimes get into discussions that I'm not quite sure where you're going. I'm going to let you walk down that path a little ways to see if it's going somewhere or it's related to the agenda item. If not, I'm going to stop you. And even as other committee or commission members, you don't have the luxury of having the attorney there for every meeting. You don't want me there for every meeting, and I don't want to be there for every meeting. But be cautious of what's on your agenda and stay on that agenda item. If you start trailing off of that agenda item, you need to get back in focus. And just a question was asked of me today by a city manager on an agenda item. He said, well, can we write these broader? I said, well, what do you mean write them broader? You're going to discuss the upcoming fiscal year budget and amendments to the budget. Well, we want to talk about some other things. Well, then list those things that you want to talk about. You can't write an agenda so that it's a free-for-all discussion. You just can't. So you can write them broad enough, but you need to write them so what? So that the reader knows what it is that you're talking about, so they have an opportunity to come and listen or participate. There's no guarantee or no requirement that the public comes to your meetings and has an opportunity to speak. There's only limited times that the public has a right to speak, but they do have a right to come to the meeting and see what the business that is occurring. That's why we post them. And that's why we need to have on the agenda items those things so the public knows what it is you're going to be discussing. So if you're sitting there and you're having a discussion, you're like, I don't think the public knows that we're talking about this, you probably need to get back on track and say, let's put this on a future agenda item. And it's not done intentionally. It happens all the time in conversation. Like now, I'm getting off track. We start talking about things that aren't on the agenda. So again, the notice should be sufficient enough to inform the public. The more critical the topic, the more specific the notice, and that's very important. If you have a hot item on there, that notice needs to be specific. Perfect example, we were talking about some zoning changes in a city, and they just put on their discussion of changing uses to the land use plan. Well, some of those uses were hot topics. They were, the single-family residentials. The public would want to know what it is we're looking at allowing or not allowing as prohibited uses or allowed uses. So again, we needed to list what were those uses that we're talking about, not just general uses, not just uses in general, okay? We talked a little bit already about the internet website posting that needs to be there. And what does the Open Meetings Act not apply to? Okay, Christmas parties, our conventions, our seminars, our workshops, provided no formal action is being taken. Social meetings unrelated to public business and testimonies before legislature and agencies. So if you're riding in a car with your commission members to a social function or to some sort of retreat, you can do that. You're allowed to do that. And if there's more than a quorum in that van, that's fine. Just don't have a meeting while you're in the van. You can talk about things that have happened in the past. Just don't talk about things that are happening next week that are on a posted agenda. So, again, minutes, a lot of times we'll get the question, what needs to go in the minutes? Sometimes you realize, how many of you kind of are confused? What needs to be in the minutes? Okay, question I get all the time, what needs to be in the minutes? Anybody? Do exact quotes from the commission members, board members need to be in the minutes? No. And I always enjoy, and DeSoto, I have the luxury that this has not occurred, but this has occurred to me before, and I always feel bad for the city secretary, because ready to get around election season, she'll call me and says, I got a call from a commission member, such and such, or from a council member, and they want this quote in the minutes. And it's not, the purpose of the minutes are not to reflect what was said, it's to reflect what was done, who voted and how they voted, okay? Your minutes can just cover the basics. Or sometimes the mayor or the council as a whole has directed the city secretary to have the minutes to be more comprehensive, okay? And that's really more of a policy of the city council, of the P&Z, but they really should just be the basics of reflective of what, who voted, what they voted on, and any specifics. If someone voted against and you want to put, they voted against it because they felt X, that's fine. But it shouldn't try to be a transcript of what occurred, because mistakes occur when you try to put that much information in the minutes. So I always encourage you, as board and commission members, there's always a lot of times it's on the consent agenda as far as approving the minutes, but go and look at them and make sure they adequately reflect what happened at the meeting. All right, role of the chairperson. What is the role of the chairperson? Okay. Presiding officer ensures the rules of proceedings are followed, maintains the dignity of the meetings, calls the meeting to order, confines the discussion, recognizes members' promotions, statements, and allows the audience participation at appropriate times. The role of the chairperson is so important because it dictates the mood. It dictates how a meeting is going to, whether it's going to be maintained in a civil manner. The role is so important. And there's really no, school for someone to go to learn to be a good chairperson. Some people are just great chairpersons, others not so great. But as far as what can they do as far as allowing the audience to participate at appropriate times, in DeSoto we've had a pretty good open policy at the council level of when we allow the citizens to participate. We allow the citizens to participate by filling out a card, and they can speak on pretty much every agenda item. Clearly can speak on anything that's a public hearing. Okay. When you get down to your committees and your P&Z, we allow people at P&Z normally to come up and speak on public hearings, and we allow them sometimes to speak on regular agenda items. There's no requirement that the public has a right to speak on a regular agenda item, or a consent agenda item for that matter. The only requirement under the law is that the public has a right to speak during a public hearing, a true public hearing, or during the period before the city council or the end of the city council meeting where we have allowed the public to come up and give comments. And that's the portion where the council cannot really essentially respond unless it's just fact-based. So there's no requirement. So that really is a policy of your board, of the commission, of the chairperson on whether or not to allow someone to speak or not to speak. And I've been at meetings at times where the mayor's looked down, we have 15 things on the agenda, and he says, okay, we're not going to allow the public to speak on these, but we're going to allow them to speak on the public hearing items, and that's fine. But what you want to do is be fair and consistent in how you enforce that. So if you're the chairperson and you're like, you look up and you see that same person there, and they're going to speak on it, and say, well, we're not going to take comments this time. Again, fair and consistent. Some cities allow public comments 1, 2, 3, or 4 times on every item. They sit down, they raise their hand, yes, come back up. Sit down, raise their hand, come back up. We're there on midnight. It's like when they say it's like watching sausage be made. That's counterproductive. That really is counterproductive. And a lot of times you'll hear the chair, there's a big group of people, and says, okay, well, I'll tell you what, I'll allot 5 minutes or 10 minutes to this organization or this group if they can speak on behalf of this organization or group. That works about 50% of the time, but a lot of times the things you'll hear, especially at the P&Z meetings and the council meetings, are those things that are repetitive, especially if you have a homeowners association. A lot of times it's just more productive to have a spokesperson for that organization come before the council and sort of give the collective thoughts of that group. All right, is the governmental body required to let citizens speak at its meetings? I just answered that. Okay. And again, the main thing is not to discriminate, unfairly discriminate. And again, you can establish reasonable restraints on the numbers, the length, and the frequency of presentations. May a member of the governmental body vote by proxy? Can you vote by proxy? Can I email James Sanders and say, James, I want you to read my email out and count it as a vote? Okay? No, we cannot do that. We cannot do that. That even includes for boards and commission members. Members may not submit a written vote without attending the meeting of the body. So, okay, secret deliberations. Don't contact members by telephone for the purpose of arriving at a decision or consensus concerning public business. Emails, voice messages, text messages, same thing. Don't meet in numbers less than a quorum for the purpose of secret deliberations. And what are walking quorums? That's an overlapping series of meetings or telephone conferences with less than a quorum. I call James, James calls the next council member, and the next council member calls the next council member. Again, that's deemed to be a walking quorum. You know, and it's interesting because if you read, those of us that still read the paper, you see local governments at least once or twice a year. You see a big story where there's still a violation and secret deliberations are occurring. Okay, and that also goes back to if you're on the Board of Adjustments. You know, the Board of Adjustments is kind of the quasi-judicial board, and you're making a determination on whether or not you're going to grant somebody a variance, not grant someone a variance. You shouldn't be meeting, or you just should not. It's like you're like a judge. The judge does not go and meet with the defendant before they come to court. Okay, you should not go and be meeting with that individual about the variance. There's nothing wrong with going out to the property and looking at the property. Same thing with P&Z or City Council. Nothing wrong with going out to the property and looking at the property. You know, if the property owner's out there and you're on the City Council, you're on the P&Z, you can't turn your back on them. You can have a conversation with them, but you really should refrain from giving them a decision or how you're going to vote and say, my decision will be based on what I hear presented to me that night. I appreciate your comments, because you do get yourself, if you say, I'm all for you, I'm going to vote in favor. What ends up happening when you come to council and you hear staff's presentation, then you vote against it. And then, well, you told me when you were out of my property that you were going to vote yes for me. You don't want to put yourself in that position. Have you violated the law? No, but you kind of put yourself in a position where you don't look real comfortable. But different being on the Board of Adjustments, as I said, you're more of a judge. So you do not want to go out and have a conversation with the property owner, because your decision is based on what you hear that night at that proceeding, and your decision is limited to that proceeding and what is presented at that proceeding. Okay, consultation with attorneys. If a situation arises during the course of a meeting that requires City Council to seek legal advice, the City Council may convene a closed meeting to preserve the City Attorney-client privilege. So again, most of you that meet have the ability to meet to get legal advice from your City Attorney. Your City Attorney doesn't have to be there. You can communicate with your City Attorney via telephone, provided your City Attorney is not an employee of the city and is a contractor, much like myself. I'm not an employee of the city, but our firm is the City Attorney. And they put that provision in the law to allow, especially for cities so they're not running up and having to pay attorneys to be at every single meeting, allow them to consult with their attorneys via telephone. In the Domestic Advisory Committee, they just did that the other day, and it was throwing an open session on a question that they had. So it's a great ability to be able to do that. Okay, we do have executive sessions on the City Council level, on the P&Z level. We can have them also, but our executive sessions are limited in nature for economic development, personal matters, real estate, and consultation with the attorney. There's a few other ones, but those are the most common ones. Again, you must post notice when we're going to go into executive session. We don't ever put just economic development or personal matters or real estate or consultation with an attorney. We need to put a specific reason on the agenda so people know that we're going into executive session. So we may put economic development on there. We don't have to give out the name of the property. Same thing with real property. We don't have to name the property. If naming it or putting it on there is going to do what? It's going to put us in a position that we're going to disclose information and we're not going to be able to compete. So again, when we're talking about economic development, a lot of times we may have, or you see the Economic Development Corporation, they have like secret words or code words, and they have that on there specifically for that purpose, not to give away what that project is or to let another city know, okay, they're competing for it also. But once that economic development agreement has been determined or negotiated, then at that point in time, it is a public item that will come back as public approval. So there's only a short period of time where you can go into executive session to preserve that information, if you will. Personnel matters, the City Council can go into executive session for personnel matters. Personnel matters means those individuals that they appoint or that they hire, the city attorney, the judge, the city manager, City council cannot go into executive session to talk about the HR director or a parks employee, because that is within the purviews of the city manager, okay? So they cannot go into executive session for that. Also, if the city council wants to have an open session and discuss the city manager, or discuss the city attorney, they want to fire them, or they want to chastise them, if you will. They don't like the way they did something. They want to get on their city attorney, okay? They can do that in executive session. It doesn't have to be closed session. Or they can do that in open session. And if it's an open session, because they want to make it public, and I don't have a right to say you have to do it in closed session, okay? I don't have that right. But I do have the right to know that I'm going to be on the agenda. So you can't just put personnel matters, and this happened recently, again, at front page at the city. They put personnel matters on there, let the city manager go home. He came back the next day, or got a call at about midnight, says, you know what, we terminated your contract with the city. Okay, can't do that, cannot do that. Let's see, okay. Procedures for closing, certified agendas need to be filled out. We don't keep it taped, we do keep a certified agenda. And the certified agenda, I usually handle it, or if you're handling it for your committee, just committee member, just make sure you know what needs to go on it, and you do have to put enough information that talks about, the announcements, the time that it began, and the subject matter, and if any action is taken. If any action is taken, any action that is taken at the end of the executive session when we come out of executive session, okay? No voting in closed session or by secret ballot. And that's normal to go around the table, get a consensus, talk about an item, that's fine. There should be no true voting there. But if you're going to go around and talk, well, I feel this way, I feel that way, yeah, I'll probably go for it. I may vote against it, I don't know. That's fine. But again, no true, how many for, how many against. No true voting in executive session. All right, videotaping. Public does have a right to videotape you. Now we're being videotaped pretty much now all the time, so you really don't see videotaping that much anymore. I remember before people would come and they lay recorders up on the dais, or they'd be sitting there videotaping, but now because everything's out on the internet, it just doesn't happen. So, with the exception of the press, okay. Skip through this. Violations, disclosure of a certified agenda or tape recording of a closed meeting is a misdemeanor. So, city secretary shouldn't be ripping open the certified agenda and disclosing it to the public unless she wants to go off on the pokey for a misdemeanor. An offense occurs if a member participates in a closed meeting knowing that she's listening, knowing that a certified agenda or tape recording is not made. Members are liable for damages for personal injury, lost wages, defamation, mental or emotional distress, reasonable attorney's fees, and court costs if an individual is slandered during a closed meeting. Okay, I was close. I said an hour, right? 5 minutes after. We started 5 minutes late. And you had the opportunity to close your eyes. I did not. Okay, so the ride is over. The ride is over. The safety bars are up. You may depart. Or do you have questions? Maybe I'm more excited that it's over than you are. I don't want to move. You're like, is it really over? Really? I really am a more exciting person than this. Bottom line, if you have anytime you have any concerns or questions, talk to your board liaison. They'll get in contact with me, and we'll make a determination if there's any type of interest, substantial interest, financial interest, where you need to recuse yourself. So, we have a question.
Talk about the ability or not ability to vote, take a vote in work sessions, whether it be planning, zoning, or city council.
All right, work sessions. Good question. Those of you that want to leave, we'll let you leave, and then I'll answer the question. Those of you who want to stay, that's a real test, right? Those that are halfway up are leaving. Those that have not got up yet are staying. The ability to take a vote or not take a vote in work session. And again, it goes back to, what is a work? A work session is a meeting. The work session is a meeting. It's just not a meeting that occurs out here on the dais. At the end of the day, it's a meeting. And the law says you can have the meeting in the back. Now we know we have to videotape the true meeting. That's what we call work sessions. We don't have to videotape the work sessions, although now some cities have started videotaping the work sessions. The work session, if you put an item on there and it says to make a decision, okay, to make a decision in the work session, you need to realize what you're doing, that you're making a decision in the work session. So you're not giving the public the opportunity to hear your deliberation. Have you done something that's illegal? No, you haven't done something that's illegal, but have you thwarted maybe the whole purpose of the work session versus the meeting, the public meeting portion? There's nothing wrong with the work session of talking about agenda items and having even having a deliberation about those agenda items. So when you come out here, your conversation's more succinct. You don't get lost in a 45, 50-minute conversation. The public has a right to come to those work sessions. But the purpose is really to discuss items, not to make final decisions on items. So there's a few things where the council gets direction and use the work session to give direction to staff to bring back a final decision, such as an ordinance. It shouldn't be made for final, in my opinion. You're thwarting the process by using the work session to make final decisions that the public did not have an opportunity to participate, and it's something that the public would have wanted to participate in, okay? If you're making decisions in work session about, the color of carpet in the library, you got to weigh that. At the end of the day, I don't think the public's going to be upset that they didn't have an opportunity to participate in what the color of unless it's like, baby blue or something. Maybe it is baby blue, never mind. But at the end of the day, you really need to say, what are our work sessions for? What is the purpose of our work sessions? And it's a work session. It's to make, to give staff direction on bringing back final decision making. So, no, that answers the question. Or
work session is not make final decisions.
You shouldn't be having a pre-council meeting with final decisions before the council meeting. Right? It's not a mini council meeting. And most of those items that are on the work session should be true work session items, where they should be coming back at a later date for some type of final decision on them. Unless it's just directing staff to do something that's more not policy driven, but it's more management driven. A lot of times staff will bring to you management decisions just to make sure. Okay, I want to make sure you're okay with this. Make sure we're all right. Is it okay to remove a tree here or a tree there? It's a true management decision. It's within their authority. And to have those discussions in work session and give them direction and be done with it, absolutely no issues with it. But when you're truly talking about your policies, you should be doing those out in the public. And those final decisions, as it relates to those policy decisions, should be out in the public where the public can see you. And if you're in the point where you start doing that in work session, then you probably should start recording your work sessions. So, any other questions? All right, appreciate it. See you next year.
Good job.